Well, my question, I guess, goes to Professor Kmiec. The President has taken the position that he has inherent authority under Article 2 of the Constitution to intercept the telephone communications in the United States of American citizens. My question for you is in two parts. First, do you agree with this position? And second, if you accept the premise of this position, is there any stopping point? Could the President also use his inherent authorities under Article 2 to enter homes, to search for materials, to seize individuals who are suspected of crimes without any judicial oversight or any statutory authority from the Congress?
First of all, to directly answer your two questions, I think the President had indeed a justifiable and plausible argument for the authority that he asserted. I think in this particular instance he both had the powers granted to him as the Commander-in-Chief under Article 2 of the Constitution that were in fact triggered, or if you will, supported by the authorization for the use of military force. But that's an interesting and to some degree different argument about the topic than we're talking about, and I want to focus on the second part. And the second part is really where I think we need to put our heads together to see where we agree and disagree. Where is the stopping point? How can we ascertain where power is being abused? And I think, Mark, where you and I disagree is on whether it's at the front end, where you have this very cumbersome judicial process, or whether we take advantage of technological sophistication and adjust the means by which we're gathering information, and at the back end make sure that information that has been gathered is only being used for terrorist prevention purposes and is not being either retained or disseminated in a fashion contrary to that objective.
You have 1 minute for rebuttal.
Well, as Doug and others know, of course, the underlying law in this instance is the Foreign Intelligence Surveillance Act. It created a legal basis to do national security wiretaps in this country. It provided for judicial authority. It allowed for the exigency when it was necessary to do the wiretap when the judge could not be reached. It even contemplated war against the United States. And there is an exigency provision in that statute that allows the President to use his sole authority for a period of time as long as he comes back to the Congress to seek approval. It is that law that was pushed aside after 9/11. And most remarkably, it is that law that was passed in the 1970s when the United States was in conflict with the Soviet Union. A far greater threat, I would argue, than the one we face today from Al-Qaeda. If we could establish the rule of law and an independent judiciary for national security surveillance in the United States at that period of time, I don't see why we would give it up today.